So Wisconsin Supreme Court threw out another Trump lawsuit today with this order. It's slightly differently formatted than the Pennsylvania lawsuit, and from other lawsuits I've seen, actually. I don't know if Wisconsin's, legal standard for their formatting is just different or what, but we're going to try and get through some of this and see what they had to say and why they threw out the Trump suit. This is Donald J. Trump, Michael Pence, Donald Trump for president versus Joe Biden, Kamala Harris, Milwaukee County Clerk. You get it. It's Trump versus Biden is the lawsuit. In the 2020 presidential election, the initial Wisconsin county canvases showed that Wisconsin voters selected Joe Biden and Kamala Harris as the recipients of Wisconsin's Electoral College votes. The petitioners, collectively the campaign, bring in action under Wisconsin Statute 9.01, seeking to invalidate a sufficient number of Wisconsin ballots to change Wisconsin certified election results. Specifically, the campaign seeks to invalidate the ballots either directly or through a drawdown of more than 220,000 Wisconsin voters in Dane and Milwaukee counties. For the record, the Trump campaign is suing, wanting to throw out 220,000 votes in cities that are going to lean Democrat. So probably people in Milwaukee or whatever who voted for Biden, maybe Rich Evans, I don't know. All the people that you know in Milwaukee, their votes would have been thrown out if this had gone through, because Donald Trump and his ilk really don't like democracy because it doesn't tend to go their way. The campaign focuses its objections on 4 different categories of ballots, each applying only to voters in Dane County and Milwaukee County. First, it seeks to strike all ballots cast by voters who claimed indefinitely confined status since March 25th, 2020. Second, it argues that a form used for in-person absentee voting is not a written application, and therefore all in-person absentee ballots should be struck. Third, it maintains that municipal officials improperly added witness information on absentee ballot certifications and that these ballots are therefore invalid. Finally, the campaign asserts that all ballots collected at Democracy in the Park, 2 City of Madison events in late September and early October, were illegally cast. We conclude the campaign is not entitled to the relief it seeks. The challenge to indefinitely confined voter ballots is meritless on its face, and the other 3 categories of ballots challenged fail under the doctrine of laches. I don't know if I'm pronouncing that correctly. The doctrine of Laches. Laches. It could also be laches, I'm not sure. After all votes were counted and canvassing was completed for the 2020 presidential election contest, the results showed that Vice President Biden and Senator Harris won Wisconsin by 20,427 votes. The campaign sought a recount in 2 of Wisconsin's 72 counties, Milwaukee and Dane. The Milwaukee County Elections Commission and the Dane County Board of Canvassers conducted the recount and certified the results. The recount increased the margin of victory for Vice President Biden and Senator Harris to 20,682 votes. V'ger6, thank you for subscribing with a 3-month streak. Oh my god, Rich Evans, yeah. The campaign appealed those decisions in a consolidated appeal to the circuit court under Wisconsin Statute 9.016a, naming Vice President Biden, Senator Harris, the Wisconsin Elections Commission, and several election officials as respondents. The circuit court affirmed the determinations of the Dane County Board of Canvassers and the Milwaukee County Elections Commission in full. The campaign appealed and filed a petition for bypass, which we granted. The campaign asks this court to reverse the determinations of the Dane County Board of Canvassers and the Milwaukee County Elections Commission with respect to 4 categories of ballots it argues were unlawfully cast. The respondents argue that all ballots were cast in compliance with the law, or at least that the campaign has not shown otherwise. They further maintain that a multitude of legal doctrines, including laches, equitable estoppel, any lawyers out there are probably wanting to stab me in the face for all these mispronunciations, unclean hands, due process, and equal protection bar the campaign from receiving its requested relief. We agreed that the challenges to indefinitely confined voter ballots is without merit, and that laches bars the relief the campaign seeks on the 3 remaining categories of challenged ballots. Is the Quinity here? Sweet. Welcome, Quinity. Hello, Baja. I'm glad you're back home. Safe. It's laches, as in it latched close. Okay, I was right the first time. Good. Sweet. A. Indefinitely confined votes. Wisconsin allows voters to declare themselves indefinitely confined, provided they meet the statutory requirements. See Wisconsin Statute 6.862A. These individuals are not required to provide photo ID to obtain an absentee ballot. On March 25, 2020, the Dane and Milwaukee County Clerks issued guidance on Facebook suggesting all voters could declare themselves indefinitely confined because of the pandemic and the governor's then existing safer-at-home order. This court unanimously deemed that advice was correct on March 31, 2020, and we noted that the WEC guidance provides the clarification on the purpose and proper use of indefinitely confined status that is required at this time. The county clerks immediately updated their advice in accordance with this decision. So basically, they said, under Wisconsin law, if you're indefinitely confined, you can request an absentee ballot because of the pandemic. We're all, in some sense, indefinitely confined. Therefore, everyone could get absentee ballots if they requested them this year. That's reasonable. Killjoy102 with 100 bits. Basically, laches means that even if you had standing or could be helped at one point, that time has passed. It's like they can't change the law after someone does something and retroactively make it a crime. Gotcha. So basically they're saying if you had issues with this, you should have sued long before the actual election. It's well past that time. The campaign does not challenge the ballots of individual voters. Rather, the campaign argues that all voters claiming indefinitely confined status since the date of the erroneous Facebook advice should have their votes invalidated, whether they are actually indefinitely confined or not. Although the number of individuals claiming indefinitely confined status has increased throughout the state, the campaign asks us to apply this blanket invalidation of indefinitely confined voters only to ballots cast in Dane and Milwaukee counties, a total exceeding 28,000 votes. The campaign's request to strike indefinitely confined voters in Dane and Milwaukee counties as a class without regard to whether any individual voter was in fact indefinitely confined, has no basis in reason or law. It is wholly without merit. That's a good sentence. Has no basis in law, in reason or law. It is wholly without merit. Beautiful. Laches. 3 additional categories of ballots are also challenged by the campaign in Milwaukee and Dane counties. The campaign asserts all in-person absentee votes were cast unlawfully without an application, and that all absentee ballots with certifications containing witness address information added by the municipal clerks were improperly counted. Additionally, the campaign challenges all ballots returned at the City Madison's Democracy in the Park events. All 3 of these challenges fall under the long-standing and well-settled doctrine of laches. Laches is founded on the notion that equity aids the vigilant and not those who slept on their rights to the detriment of the opposing party. Then there's a citation. Application of laches is within the court's discretion upon a showing by the party raising the claims of unreasonable delay, lack of knowledge the claim would be raised, and prejudice. For obvious reasons, laches has particular import in election context, as one noted treatise explains. Extreme diligence and promptness are required in election-related matters, particularly where actionable election practices are discovered prior to the election. Therefore, laches is available in election challenges. In fact, in election contests, a court especially considers the application of laches. Such doctrine is applied because the efficient use of the public resource demands that a court not allow persons to gamble on the outcome of an election contest and then challenge it when dissatisfied with the results, especially when the same challenge could have been made before the public is put through the time and expense of the entire election process. Thus, if a party seeks extraordinary relief in an election-related matter, fails to exercise the requisite diligence, laches will bar the action. So, they're basically saying, in the context of this case, it's very clear that the Trump campaign waited to see the results and then specifically found areas in places like Wisconsin, because this is a Wisconsin lawsuit and going to the Wisconsin Supreme Court. They basically waited for the election results, figured out, based on the results, which votes do we have to get thrown out in order to steal the election, and then targeted those votes with lawsuits. The court is saying you can't do that. It's like, you know when you're a kid and you're playing tag or something, and you go and you tag a kid, and one of them's a little shit, and they make up rules on the spot to why they're, like, not tagged. They're like, no, I have a force field. You can't make rules up after it's already happened, because then you're just targeting what's happening in order to make the rules fit so you win. You can't do that. All these sort of election issues need to be dealt with prior to the election, because you didn't go with like, due diligence to actually correct something, right? Interesting. Calvin ball. Yeah, basically. Any Calvin and Hobbes fans will know what that is. No tag backs. Although it disagrees the elements were satisfied here, the campaign does not dispute the proposition that laches may bar an untimely election challenge. This principle appears to be recognized and applied universally. See E.G. Jones v. Markowitz, Quallenbush. Those are interesting names. The obligation to seek injunctive relief in a timely manner in the election context is hardly a new concept. And then there's a bunch of stuff about that. This case may be a paradigmatic example of why. Paradigmatic. Gotta look that one up. Gotta expand my vocabulary. Paradigmatic, serving as a typical example of something. Paradigmatic. Okay. Interesting. This case may be a paradigmatic example of why. The relevant election officials, as well as Vice President Biden and Senator Harris, had no knowledge a claim to these broad categories of challenges would occur. The campaign's delay in raising these issues was unreasonable in the extreme, and the resulting prejudice to the election officials and other candidates, voters of the affected counties, and to voters statewide is obvious and immense. Laches is more than appropriate here. The campaign is not entitled to the relief it seeks. Beautiful. Absolutely beautiful. Genghis Kanye 77, thank you for following. And Chesabel with 100 bits. Hanukkah time. Have a good stream, everyone. Sweet. Enjoy all your Hanukkah fun. Get your dreidels and win some, I think they're called gilt, the little chocolate coins. Have some fun. Seriously. A reasonable delay. First, the respondents must prove that the campaign unreasonably delayed in bringing the challenge. What constitutes an unreasonable delay varies and depends on the facts of a particular case. Citation. Here, the campaign unreasonably delayed with respect to all three categories of challenge ballots. Regarding the campaign's first challenge, Wisconsin law provides that a written application is required before a voter can receive an absentee ballot, and that any absentee ballot issued without an application cannot be counted. See Wisconsin Statute 6.811AR. The campaign argues all in-person absentee votes in Dane and Milwaukee counties were cast without the required application, but both counties did use an application form created, approved, and disseminated by the Chief Wisconsin Elections Agency. This form, now known as EL-122, is entitled Official Absentee Ballot Application Certification. It was created in 2010 in an effort to streamline paperwork following the 2008 election, and has been available and in use ever since. The campaign does not challenge that any individual voter's ballots lacked an application, and otherwise appropriate and timely issue. Rather, the campaign argues this application is not an application, or that the municipal clerks do not give this form to voters before distributing the ballot, in contravention of the statutes. Regardless of the practice used, the campaign would like to apply its challenge to the sufficiency of EL-122 to strike 170,140 votes in just 2 counties, despite the form's use in municipalities throughout the state. Waiting until after the election to challenge the sufficiency of the form application in a statewide for the last decade is plainly unreasonable. Plainly unreasonable. Good verbiage. Harry K5 with 20 bits. William Barr is stepping down. Confirmed. More likely he did a "you can't fire me, I quit." Trump probably just fired him on Twitter like he fires everyone because he's a bitch. Dr. Zandu, thank you for subscribing with Prime. The second category of ballots challenged are those with certificates containing witness address information added by a municipal clerk. Absentee ballots must be witnessed, and the witness must provide their name, signature, and address on the certification printed on the back and side of the envelope in which the absentee ballot is ultimately sealed. Citation. While a witness address must be provided on the certification for the corresponding ballot to be counted, the statute is silent as to what portion of an address the witness must provide. You get it. It goes on and on like this. It's very long, so we're not going to read this whole thing by far. Let me see if I can just get down to the conclusions. But you get it. Yet another Trump lawsuit that's clearly just targeting so they can try and get the election thrown out because they lost. Absolutely ridiculous. Let me see, at the very bottom. Lord Cuckbucket with 50 bits. Trump and the GOP legislators literally tried rigging the elections by agreeing to voting rules but not making the agreements into laws in states like Wisconsin so they could try and remove votes afterwards. You know what would be far easier and wouldn't have failed so spectacularly? Having popular policies that helped people. Republicans can't do that. They literally can't. Their policies are antithetical to public health, to public wealth, to everything. They serve to make a very select few people richer. That's basically all they can do. It's ridiculous. Are these just citations? I don't know. Either way, interesting stuff. Here's a link if you want it. I'll put it in the chat here. It's a very interesting document if you're into that sort of thing. Kind of hoping someone like Leonard French or someone with actual legal knowledge will go over something like that at some point, because I'd love to see actual lawyers kind of get into the nitty-gritty of this stuff. Genghis Khan 77, thank you for subscribing. Very interesting. Another Trump lawsuit bites the dust. And once again, Biden wins the election. Moving on.